A Robb Elementary School teacher is taking the first step to possibly filing a lawsuit against the gun manufacturer. Amelia Marin filed a petition to force Daniel Defense to sit down for a deposition and provide materials on how it markets AR-15 style rifles like the one used in the Uvalde shooting. Now, some are wondering what legal protections gun makers have, especially following a mass shooting.
So if you're shot by a person who criminally misuses a weapon, this law would block you from suing a firearms manufacturer.
But there are exceptions.
If you buy a firearm that is defective, if you knowingly transfer a firearm knowing that that firearm will be used to commit a crime of violence,
you can sue when there's an allegation that the manufacturer or dealer violated an underlying statute, either a federal or state statute that is, quote, applicable to the sale or marketing of firearms.
And we just saw this play out in 2015. The families of 9 Sandy Hook victims sued gunmaker Remington for the way they marketed the weapon used in that mass shooting.
The allegation by the families was that Bushmaster was marketing this gun to be used for offensive, violent conduct.
In February, Remington settled for $73 million.
But I don't think it really resolved the ultimate legal question as to just how big an exception is this to the federal immunity shield.
A district court judge has thrown out a federal lawsuit against Daniel Defense for a shooting that happened in April of 2022. Welcome to another installment of the Connecticut Gun Bench. Today's video is brought to you by P.A.N. Firearms, LLC. P.A.N. Firearms, your NRA certification of multifaceted gun training. You can reach us at 203-300-6343 or use our website at www.panfirearmsllc.com. As always, there'll be a link in the description box below. And if you like channel like content, what I do here, you can support me with a link. Everything is appreciated. And once again, PSA, if your comments disappear from being posted, I'm not doing it. There is a growing problem across this platform of specific channels, specific content, and specific comments being removed without very much notice. So if your comments disappear, I'm not doing it. Let's talk about this. And this is monumental news as far as I'm concerned. But a federal district judge by the last name Claude Hilton dismissed a federal lawsuit filed by victims of a shooting that happened in April of 2022. Now, this happened in Washington, D.C. Apparently, this person set up a rifle on a tripod in his apartment and was just randomly shooting at people on the streets, which caused a massive lockdown around the area of schools and universities. Now, a couple of people and 12 other defendants came forward, filed a lawsuit against Daniel Defense, not against the shooter, but Daniel Defense. And this federal court judge said this falls well within PLCAA. Now, this is a big deal, because we know there are multiple lawsuits like this one floating around, multiple lawsuits, where they are blaming the manufacturer of the firearm that is used and not the person who is pulling the trigger. This has a twofold effect. One, people get paid because there are a cabal of lawyers across the country, and I've talked about this before, who basically, as soon as a shooting happens, they try to find out who the manufacturer is and then run to all the defendants and try to get them on board with a lawsuit against the gun company. Sometimes the company will settle, as in what happened with the Sandy Hook ordeal. But you have to remember that Remington did not settle. It was the insurance companies that basically backed Remington who settled with the people who filed the lawsuit, and not all the families filed lawsuits. But that's about getting money. It's not about justice. Okay, let's just cut the crap. The other effect it's going to have, of course, is to keep gun companies in the court system constantly fighting frivolous lawsuits that are filed against them. Okay, but I want to come into here. Daniel Defense wins important gun rights case in Virginia, and this is a big deal. A senior U.S. District Court judge in Virginia has dismissed a federal lawsuit filed by 2 victims of a 2022 school shooting against Daniel Defense and more than a dozen other defendants, saying their allegations essentially do not pass legal muster under the Protection of Lawful Commerce in Arms Act. The 11-page ruling by U.S. District Judge Claude M. Hilton, a Ronald Reagan appointee, said plaintiffs Karen Lowy and Antonio Harris, who were wounded in the April 2022 shooting at Edmundburg School in Washington, D.C., failed the proximate causation prong of the PLCAA's predicate exception, and their claims of negligence and negligence per se far no better. I assume they mean fair, but I can't say. But we know that PLCAA came law under George W. Bush, and what it basically does, and these people always say it protects the gun industry from lawsuits. No, it does not. If the manufacturer makes a product that is faulty and causes injury because of that defect, they can be sued. But they cannot be sued when somebody takes their product and uses it in an illegal manner. Suing the gun manufacturers because somebody used their product to shoot someone else is the same thing as the SUV manufacturer being sued for what happened in Waukesha, Wisconsin, and a knife manufacturer being sued for what happened in Idaho. Absolute tripe and nonsense. There's only one person responsible, the person who actually uses the implement in a nefarious manner. So PLCAA became law, means of protecting the firearm industry from junk lawsuits, attempting to hold gun makers and retailers responsible for crimes committed with the products they manufacture and sell. A flurry of such lawsuits, supported by the gun prohibition lobby, were unleashed more than 2 decades ago, apparently with the intention of bankrupting or financially devastating the firearms industry. Exactly. PLCAA was the Congress's response, and it both stifled and infuriated the gun control movement, which repackaged itself as gun safety advocates, because that's all they say now. Gun safety, common sense. They basically just renamed what they're all about. Okay? They went from gun control advocates to gun safety advocates. But it's the same thing. Okay? However, contrary to claims by President Joe Biden and other anti-gunners, the PLCAA does not and never did make it impossible to sue firearm manufacturers or the gun industry. There are exceptions to the PLCAA, as noted by Judge Hilton in his ruling, to ensure that it does not insulate firearms companies against lawsuit resulting from their unlawful behavior. Here, Judge Hilton explained defendants qualify for the PLCAA's protection and plaintiffs failed to invoke the Act's exceptions. According to an article in Law 360, the list of defendants in addition to Daniel Fence include Bravo Company USA, Vista Outdoors, Federal Cartridge, Loyal 9 Manufacturing, Hearing Protection, and Torque Mag Incorporated, Fiocchi of America, Magpul Industries, and Surefire, Fostic Incorporated, Centurion Arms, and FAP Defense Incorporated. It almost feels like reading this list of manufacturers. I'm sitting there going, what did they do? Basically looked at every single part on there and then just went after the manufacturer of that part. It's amazing. But as explained in the ruling, Lowry was waiting outside the school to pick up her daughter, and Harris was a security guard at the school when the shooting started. Both were wounded, while Lowry's daughter sheltered inside the school. Ultimately, the gunman took his own life. At the time, Reuters reported the gunman, identified as Raymond Spencer, apparently fired the shots from an apartment complex. When the police breached the apartment pinpointing the shooting, they found the shooter. In his ruling, Judge Hilton observed much of the plaintiff's complaint concerns defendants' marketing to Virginia residents. Now, this whole marketing idea is basically how the Sandy Hook plaintiffs, if you want to call them that, circumvented the PLCAA because they used the Connecticut law, commerce law, to get around it. Okay? On shooter specifically, Judge Hilton goes on to observe, the plaintiff does not suggest defendants control such evidence of shooter's reliance and does no more than speculate that shooter, like other young men in Virginia, observed defendants' advertisements without more support. These pleadings fail to raise plaintiff's right to relief above the speculative level and can proceed no further. Okay? So what the plaintiff's claim is that the shooter basically looked at Daniel Defense's advertising and that inspired him to go do this thing. And the judge said they could not show an actual causation connection between the advertising of Daniel Defense and what actually transpired that day in April of 2022. And the judge is correct. So let me come out. This is a big deal because there are multiple such lawsuits floating around the country right now. And as I said, there is a cabal of lawyers across the country who basically do nothing but contact victims of shootings to get them on board with lawsuits against the gun manufacturers. Notice, and they hardly ever sue the person who pulled the trigger. Basically, no, they go after the gun manufacturers. Good, well, let's just get to the nitty gritty. That's where the money's at. But this is huge. This is huge. So We're going to wait and see if they're going to appeal this to the next level. I mean, I'm talking about the plaintiffs who filed the suit in the first place, or if they're just going to basically lick their wounds and go home. But this is huge because it's setting a tone and tempo for all the other lawsuits coming up behind it. But let me know what you think. As always, you can leave your comments in the comment section below. And as always, any statements of violence or statements that lead to violence will be removed. Please like, share, comment, subscribe. Don't forget to hit that notification bell so you're notified the next time a video goes live. I'm going to see you on the next one. Peace.